distinguished guests, esteemed speakers, and fellow attendees. It is my great honor and pleasure to welcome all of you back to the conference. So this is the panel discussion, second panel discussion, and it will be held on investor-state dispute settlement and indigenous rights in conflicts. So our panelists will share their thoughts, perspectives, and real-world applications, and of course, we encourage you to engage with them through a question and dialogue. Our panel members are Professor M. Sornarajah, Dr. Maciej Zenkiewicz, and Dr. Shamila Dawood, Dr. Caroline Henckels, and Ms. Niroshika Liyana Muhandirum. To begin this session, I would like to introduce our chair, Professor M. Sornarajah. Professor M. Sornarajah is an Emeritus Professor of Law in National University of Singapore and a former CJ Koch Professor in Law. He has also served as the Tunku Abdul Rahman Professor at University of Malaya and Head of the Law School at the University of Tasmania. Professor Sornarajah holds degrees from University of Ceylon, Yale Law School, London School of Economics, and King's College of London. He has been a research fellow at Cambridge Centre for International Law and Max Planck Institute, Heidelberg. So now let me introduce our panel members. Dr. Maciej Zenkiewicz, Assistant Professor, Department of International and European Law, Nicolaus Copernicus University, and Dr. Shamila Dawood, Senior Lecturer of the Department of Commercial Law, Faculty of Law, University of Colombo, and Dr. Caroline Henckels, Associate Professor, Faculty of Law, Monash University, and Ms. Niroshika Liyana Muhandirum, Senior Lecturer, Department of Legal Studies at the Open University of Sri Lanka. So we are very grateful, all of you, to taking your valuable time and joining with us today. So may I now respectfully call upon our panel chair, Professor M. Sornarajah, to take over the discussion here on.
Thank you very much for that introduction of the speakers. Saves me the time of introducing them. This is a relatively new area of investor-state arbitration concerned with indigenous people. There was no concern with anyone in South Asia in international law. We did not exist because we were not considered civilized nations in the old days. So we did not have personality then. After decolonization, of course, we became independent states, and the people of South Asia were recognized, hopefully, as people in international law. But by no means the indigenous people, if they did exist, as distinct from ordinary people. So as far as international law was concerned, most settler communities were founded on the basis that they were terra nullius, which meant that no people lived in them. And that was a fiction, because Australia, the North Americans, all had people living in them, but they were presumed not to exist as human beings virtually, or have the capacity to hold territory. Now we are in a new age of investment treaties, and we know that they are asymmetric treaties in the sense that there is a power relationship that attends the making of investment treaties. It is always made with a capital exporting state, the other state being a capital importing state, so that there is a genuine power imbalance. It is the classic example of what Chinese international lawyers would call unequal treaties. So in the context of unequal treaties, and in the context of the old idea that indigenous people simply don't exist, we have this challenge that arises in modern international law simply because of the fact that there are some rudimentary traces of the recognition of indigenous rights, particularly in the UN Declaration on Indigenous People. So the issue that we are going to discuss, the panel is going to discuss, is whether there is an adequate representation adequate means of protection of the interests of indigenous people when disputes that affect them arise before international investment tribunals. So there are 4 speakers. The manner in which the panel would address the subject is that each would make a presentation of less than 8 minutes. And this is a strict limitation that is imposed on them, and it would be enforced. By what means? By all means. Okay. So, be on guard, okay? I got a phone to throw at you. Okay. So, the first of the rank would be Maciej, yes.
Thank you very much. Of course, thank you very much for being here, but because I have only 8 minutes, I will restrain myself to thank you, the organizers, and all of you for being here and listening to our presentations. Can I ask you for a slide presentation, please? I'm working in the academic forum on ESDS, and we proposed a working group on local communities. That was like 3 years ago. We gathered a bunch of the very renowned scholars. So, apart of me, everybody's renowned there. So, we have Nicolaus Perrone, we have Lorenzo Cotula, we have Leila, we have Ladan, we have Gloria Alvarez. So, of course, we wanted to bring all of that expertise. However, this is a difficult job because this is very policy-oriented paper. The idea is to present something or to prepare something which can be presented for states and somehow influence states. So this is very different from writing academic paper. We start with the local communities because we didn't want to restrain ourselves to indigenous people. And we end up right now to talking about third-party rights. Can I ask for next slide, please? If you look at the terminology, this is what you can see, that indigenous people, of course, they are already recognized group because it took years and a lot of struggle, but we have some genuine substantial rights attached to indigenous people. However, we thought that just restraining ourselves to indigenous people would be not the response for the problem. Because many times you will have the local communities in Colombia who are not recognized under Colombian law as indigenous people. You will have some local communities which are severely affected by the investment, but they are not under the labor of indigenous people. So we made our work a little bit harder to broaden that scope, and therefore we used third parties, affected third parties, as the terminology which is already in use within the working group. Next slide, please. So here you have definition. Of course, I'm very happy to share that. At the beginning, I should address that all of the comments are mine, and the responsibility is mine, not of Lorenzo, Nicolaus, etc., because we are still under discussion and there is a lot of tension, friendly, but tension. If we see the next slide, please, that the problem is, apart from terminology, which we move to third parties, can I ask, next slide, is the problem that, first of all, I've just learning about the subject, which is quite new, but since 2017 we have more and more papers on that and the legal contribution and academic contribution. There are at least 4 postures, or you can identify 4 postures. First of all, that this is just minor reform in ESDS, which can accommodate and respond to that problem of those unheard voices or those invisible actors. The second is, of course, the moderate or complex reform should be addressing that problem. The third one is much more like Ruji's work on human rights and business. So no silver bullet, it should be various pillars. So ESDS as well, domestic law. And the fourth, unfortunately, gathering strength is that the system is beyond repair. This is, of course, something which we cannot present as in the report for states, but this is something which has to be acknowledged, that there are more and more voices saying that simply that the whole system is corrupt. rooted in the discrimination and based on that inequality. Therefore, participating in the reform is participating in prolonging that system. We try to, next slide please, we try to identify the possibilities and what mechanism we have in hand. So options for reform, we have existing mechanisms which obviously none of them will respond to the problem. But I identify the existing mechanism which can be modify, and of course introducing something new on the table. So of course we have third-party participation, and here we have third-party participation sensu stricto, so the parties which can participate, which is very, very rare situation, and amicus curiae, which exists. It's a little bit like the candy shop for the kids looking through the window. So it gives you some perspective that there are sweets, there is a possibility to interfere, but at the end of the day, you are just watching that from the street and you are not getting your ice cream or lollipop. So amicus curiae, as stands for today, for me, of course, this is not something which will be solve the problem and address properly the issue unless we change that. Of course, FPIC, it was already mentioned. FPIC is heavily rooted within indigenous people. So of course, many constitutions in Latin America, many international law documents recognize that right for indigenous people. And of course, the other tactics as I call it, so inclusion new obligation into ESDS proceedings. So of course, we have that trend, including human rights, environmental law, corporate social responsibility. In my opinion, it can be done on the various levels. So of course, through treaty provisions, but also through domestic law. If we have domestic obligation on human rights, the investor should be obliged to follow that. If not, his investment can be illegal, and he will be deprived of the investment. And of course, via interpretation of treaties. The other ideas which come up during our work was precisely carved treaty provisions regarding right to regulate. So simply give the right to the state to the uncompensated possibility to expropriate or affect the investors. And of course, judges' activism related to third-party rights. We have seen that in the Bear Creek. So the majority was against, but Philip Sands clearly stated how is his vision regarding indigenous people. If we had 3 Philip Sands in that panel, that would be kind of the step forward and, the possibility to move the system. So the solution doesn't necessarily mean that we have to change treaty provisions. It also means the change in the attitude. The last slide, if I will find 1 minute. This is, of course, counterclaims, which I'm not big fan of counterclaims. We are mentioning that. We are still assessing, and by mentioning, I'm not saying that this is the solution. This is what we recognize as a possible tools, but still there is a question how this will be effective. So the counterclaims, benefit sharing, multi-actor contracts, what we've seen in Australia, Canada, so making that tripartite obligations under the contract, and then forcing or making in the ESDS the contractual rights protectable. And joint declarative statement by states. Why not? 2 states could simply say what they do mean by those rights and who is benefiting from those rights. Of course, the requirement that investors exhaust domestic remedies. This is Calvo doctrine coming back, and this is, in my opinion, very, very good way or the possibility to enforce and to have the third party being heard. And of course, the creation of dispute settlement mechanisms, which includes third parties. This is a little bit science fiction for me. I don't think that this is possible to achieve. As my time has expired, I'm waiting for your question to finish my presentation. Thank you very much.
Thank you. Then next is Shamila.
Yes. So thank you. Yes, I look this problem from the approach to social license to operate, that is to link the foreign investors, indigenous people, as well as the host state. So as per the World Bank Group, it reveals that as per 2023, there are an estimated 476 million indigenous people worldwide, represent 6% of the global population. So as Dr. Maciej, he was explaining the terms of reference, since there is no such definition for indigenous people, they have a unique identification to identify who are indigenous people. So their cultural identity and survival are deeply connected to their environment. Therefore, right to environment is foremost important to protect other rights of indigenous people. So when I addressing these issues connected to ISDS and indigenous rights in conflict, as a legal researcher, we often examine the adequacy of existing laws and their effectiveness in addressing contemporary issues. So this involves not only assessing whether current legal framework are sufficient, but also considering the moral duties that laws impose towards the other individuals, the environment, and social at large. So the intersection of law and morality emphasizes the importance of ethical consideration in legal practice, even in legal research. So in the context of environmental law, the moral duty to protect environment is increasingly recognized for sustainable development. Therefore, I believe the bridging the gap between foreign investors, host state, indigenous community would be the ideal way to minimize risk of expropriation and as well as the protect indigenous rights. So this is all about building trust. So it's building a belief system. So if you see UNCTAD case statistics as of 2022, at least 175 cases have been brought against the host state on environmental ground. So amounting to about 15% of all nearly 1,200 cases. So these disputes, majority of these disputes, when it's come to environmental matters, it is the foreign investor failed to adequately consult the local community or involve them in the decision making when it's come to environmental sensitive projects. So therefore, the host state may be held accountable if the protection of indigenous people's environment result in a loss for the foreign investor when interacting with foreign investors and indigenous people in conflict. So this emphasizes the mutual obligation between foreign investors, host country, and stakeholders regarding the right to consultation and the duty to consult. So these two factors are important aspects of social license to operate. So the social license to operate is a social the acceptance license rather than the government approval license. So some argue the term social license is flexible and that is adoption by companies represent an explicit acknowledgement that civil society possesses the power to challenge companies' right to operate. So it is challenging for foreign investors, including host state, how to initiate this process effectively. Therefore, some studies suggest to having kind of a criteria or a rubric of assessment using several scales to evaluate the entire process of the SLOs, that is a social license to operate. So when you see the social license to operate, I identify there are main 3+. If you put it into the pyramid, the base level is legitimacy, and then credibility and trust. So the local communities have legitimate expectation driving tangible benefits from a project, a company that contributes to overall well-being of the community or region. So the legitimacy include both economic and social dimensions. According to Thomas et al., a lack of legitimacy relates with the lower likelihood of approving projects. So next, building credibility depends on transparency and accountability. So which manifest at two levels, that is acceptance and approval. So when the level of credibility increases, the project can advance from the acceptance to approval. Acceptance means it's a passive acceptance. Approval is an active involvement of stakeholder in the particular project. So the final is a trust. So vital relations component that is built over a time. So whereby local communities develop confidence in the investors, intention and action. So the trust is reinforced by consistent, respectful engagements, responsiveness to community concerns, and demonstrate to commitment to uphold ethical principles that prioritize the responsible business conduct where corporate social responsibility emphasizes. So there are several cases. Tribunal emphasize this local participation and so on. In very recent case, Bear Creek Mining Corporations versus Republic of Peru, where the tribunal discussed the SLO. That means the majority of the tribunal agreed that the host state should establish a legal framework for efficient consultation with the local population. So the dissenting arbitrator in this case contended that the foreign investor also play a role in obtaining local trust, highlighting the importance of corporate accountability and the integration of human rights consideration in investment disputes. So he emphasized the ILO Convention 169, where it's emphasized, and also the free trade agreement provisions that the both parties should adhere to international law. Therefore, my argument is the SLO that include right to consultation and duty to consult, that is included in the UN DRIP declaration as well as the ILO convention, that is free, prior and informed consent. So that is the only way I believe to bridging the gap, rather than we always focus on the including the provisions in the bilateral investment treaties or free trade agreements. I believe these both should be in place to protect indigenous people. Thank you.
Thank you, Shamila. Thank you. And do we have Caroline Henckels next? Caroline, how do you contact her? Otherwise, you go next and we can have Caroline later. Niroshika, yeah. Oh, there's Caroline.
Hi, can you hear me?
Oh, I know, yes. Yeah, it's Caroline I know very well. She's, sorry.
Okay. Good afternoon, everyone, and thank you very much for the opportunity to speak. I'm joining you today from the unceded lands of the Kulin Nations in Australia, and I recognise the sovereignty of their peoples, which was never ceded, and acknowledge that the legacies of European invasion and colonisation ongoing throughout Australia. I would like to speak about something a bit different. I would like to speak about how the framing of investor claims as rights, as a certain type of right in investment law, creates structural imbalances, particularly when such claims conflict with the rights of Indigenous peoples. And I'll argue that framing investor entitlements or investor claims as rights claims elevates those claims to a privileged position, often at the expense, or usually at the expense, almost always perhaps, of collective rights that are tied to land, culture and self-determination. And so my starting point when I began to think about this a while ago is that investment tribunals frequently employ the language of rights, unthinkingly it seems, or perhaps based on a whole lot of assumptions that are never explained. And they use the language of rights even though investment treaties do not use this terminology. Now, what does it mean to describe something as a right? When people talk about rights or use the language of rights, they invoke moral claims justified by reference to whatever theory of justice they espouse. And in doing so, it's intuitively tempting to regard something that is a right as inviolable and absolute in the sense that it cannot be infringed upon, that disputes involving rights must always be resolved in favour of the rights holder, or that rights will always trump any competing interest. At the very least, once something is characterised as a right, its normative significance is elevated and the state's political capacity to regulate whatever that thing is significantly diminished. And so the way in which this is played out in investment law is that investment tribunals' use of the language of rights gives investor claims a sense of concreteness and inalienability, and it imbues their claims with moral and legal weight, with the effect of buttressing the normative strength of investor protections at the expense of host state regulatory power. Now, you might think that because they employ the language of rights to talk about investors, that Indigenous rights or rights held by Indigenous peoples would also be given the same normative moral weight. But this is not the case for Indigenous rights or other human rights. Indigenous rights, as we know, have collective and relational dimensions and are often tied to the environment and cultural heritage. Unlike investor rights, they cannot be quantified in dollar terms. I say investor rights in inverted commas, of course. And they're treated as diffuse, intangible, aspirational, and perhaps something that's only capable of progressive realisation. So they're seen in very different ways. And the way this plays out, this structural imbalance, is it really shapes the outcomes of disputes, because the scales will always be tipped in favour of the investor as a starting point, because investor rights are concrete and measurable and individually held, which really aligns with the ICS framework, which is rooted in individualism and the protection of private property. Now, how has this happened? Why has this happened? There are lots of reasons. Paul Brody, who I think is with you in person, and I wrote about this a few years ago in the Maiden Journal of International Law, and he is certainly far more qualified than me to explain the reasons why this may have happened. But I suppose then the question is, well, what can be done about it? Well, of course, many things need to be done, from tinkering at the margins to raising the whole regime to the ground, or somewhere in between. And, minds, of course, differ on this. But I think in relation to this issue of linguistics and discourse that I've highlighted, one small role that we can play as scholars is by critically analysing the language that's used in ISDS and the normative implications that flow from that. And I think as scholars, we need to be really precise when we're speaking about the law and describing the entitlements that investors hold under investment treaties, to avoid inadvertently reinforcing this discourse of investor rights. So thank you very much for listening, and I look forward to our discussion.
Thank you, Caroline. Yes. So that's fine. Yes. Shall we, Niroshika? Yeah.
Yes, Professor. First and foremost, I am deeply honored and privileged to be in the presence of such a distinguished panelist. Thank you for the opportunity. The area that I am going to present is whether the investment treaties of South Asia are compatible to protect the rights of the indigenous people, and what is the application of treaty-based approach in this regard. So, if I may discuss the background of this whole scenario, one of the key controversies in international investment law regime is how to reconcile the tension between the investors' rights with the protection of social welfare concerns, such as the protection of rights of the local community. This conflict often arises because of the textual indeterminacy of the investment agreements, which has resulted in consistent and undesired conclusions. Most of these investment treaties, as we are already aware, that they were drafted and came into existence before 1980s or around 1990s. And they are designed basically having the intention of attracting and protecting the foreign investments by granting extensive rights to the foreign investors with a limited or sometimes with no specified space to exercise the right to regulatory power of the host state. However, when the states realized that these investment agreements are not harmless documents and they are not the tools that can attract the foreign investments, and they can bite the state measures as well, resulting in investor-state disputes, then the states have started reacting those measures in such a way, ranging from terminating the bilateral investment treaties to making reformations to the existing bilateral investment treaties. We know that states such as Bolivia and South Africa, many of South African states, they have terminated their bilateral investment agreements, while countries such as USA and India, to some extent, making reformations to the existing investment treaties. However, my focus here is to discuss or deal with the treaty-based approach. By explicitly including clauses that safeguard the host state's right to regulate, it ensures that investment protections do not override the host state's ability to pursue legitimate public policy objectives, such as protecting cultural heritage, environment, or public health. In other words, this treaty-driven approach means expressly accommodating the regulatory power of the host state within the text of the investment treaty agreement itself. According to me, I feel like I know that there are several lacunas as well, but this treaty-based approach can oust the indeterminacy of the investment agreement while restraining the judicial activism, and also this approach strengthened to restore the balance that missed during the first generational BITs, and also mitigating the regulatory chilling effect, and it enhances the public trust. And the usability of this treaty-based approach can further be justified based on Article 31(1) of the Vienna Convention of Law of Treaties, and accordingly, a treaty should be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the lights of object and the purpose. That is why BIT is considered as the main source of dispute main source of interpretation when a dispute arises. When we see specifically whether the bilateral investment agreements of South Asia are compatible with states' obligation to protect indigenous people's rights, I have attempted to answer to that question by mapping all the bilateral investment agreements of South Asia. I should tell that there is no explicit reference to accept the rights of indigenous rights within the text of the bilateral investment treaty. And especially if we focus the BITs of Sri Lanka, Nepal, Bangladesh, those bilateral investment treaties were concluded around 1980s to 1990s. Specifically when it comes to Sri Lanka signed the last bilateral investment treaty in 2012. After 2012, country has not entered into a single bilateral investment treaties. But this new treaty approach or modern treaty approach was arisen around 2000, and Sri Lanka is yet to adopt this modern treaty approach. And however, a number of bilateral investment treaties in the globe, if I expressly tell you that, for instance, countries such as Netherlands, they have included an exemption that recognizes the state's right to protect Maori community within the text of their investment treaty. And Energy Charter Treaty also has allowed the contracting parties to adopt measures designed to benefit investors who are Aboriginal people. Canada's new model foreign investment protection agreement also includes preferential treatment for the Aboriginals in its annex, and Malaysia has similarly excluded measures designed to promote economic empowerment of Bumiputra's ethnic group from the scope of its bilateral investment treaty. But when we again compare this global scenario with the South Asian region, to some extent we can exempt India, and other than India, none of the other states place a significant emphasis on the protection of no on human rights, nor on cultural heritage, environment, or corporate social responsibility. Why have focus on those provisions? According to me, I feel like, even the CSR obligations, general exemption clause, exemption to expropriation clause, if we have drafted those provisions in a broad way, indicating the protection of cultural heritage, environment protection, accepting them as an exception to the treaty obligation, then the states will have a proper latitude to legitimize their right to regulatory power. Compared to other states of the South Asian region, India's bilateral investment agreements with Belarus, Kyrgyzstan, Brazil, and UAE, they are particularly significant, and because unlike other countries like Nepal, Sri Lanka, and Bangladesh, these investment treaties of India, they include CSR provisions, general exemption clause, and expropriation clause, and also right to regulatory clause also in some investment treaties to support the interpretation and protection of indigenous people's right. So finally, I would like to conclude stating that though this treaty-driven approach is not a panacea that the existing crisis of the investment law regime, I feel like it is a significant step towards the rights direction to maintain a proper balance between investors' rights and the host state's regulatory power.
Thank you, Niroshika. So I'll ask a few questions, and then we will open, let you ask any questions if you have any. Most of the solutions that you suggested, Maciej, refer to procedure, right? Which call for the assumption that ISDS is a good system, right? I mean, the whole debate is about whether ISDS is a good system or not. So there's a problem with the solutions you suggest, because but many people like me should say that ISDS should be thrown out of the window, right? So you have a problem there, don't you?
Yeah, I do. I do, and for that reason I mentioned those four postures, and we acknowledge the fourth one, or the first one, depending from which angle you are saying, as Professor Gatti, Professor Sornarajah, and many others are saying that this is reviving the dead corpse, any kind of the reform. However, because, as I said, we are policy-minded working group to present something for states, and it would be rather awkward for us to go to the working group Free UNCITRAL in Vienna saying, throw that through the window. So we are
But what's your own view about ISDS? I mean, are you participating in a fraud, or are you sort of legitimately providing a solution?
I think that I'm still on my way to reach the conclusion, which I don't know if you would like or not. We are acknowledging all of the problems, and we are perfectly aware that maybe there is no solution within the system. This is what I missed, because you have seen that there was one slide missing, solution outside of the system. I think, and I really take from the attitude of Ruji regarding business and human rights, that there is no silver bullet, there is no solution within ESDS. We should strengthen the domestic system, we should pay attention to the constitutional courts. For example, many constitutional courts, Colombia, Ecuador, other countries, they are taking some actions against the system because they are probably agree with that attitude that the system is beyond repair. I'm quite skeptical about the system, but the system we have sunset clauses, and if we want to throw it or not, it will be in motion for 20, 30 years still. So, dodging your question, obviously, because it's very awkward for me to answer directly, I think this legitimate work to do to find the solution within and outside the system, even if, and as I said, in the group we have more skeptical people rather than enthusiasts of the ESDS. Even if many of those, I didn't mention Ibironke, for example, though Ibironke in her last article said the same, that this is reviving the dead corpse. You know, the system is broken, and from the very beginning. Therefore, okay, we are doing that work, but you know, maybe there is no solution within the system. So I perfectly acknowledge that. I think that the system will not repair itself. For now, the system should be looked holistically, making more importance for the domestic courts, maybe reviving Calvo clause, maybe putting the input of changing the system in that, like putting the obligation on the investor as well. However, in my opinion, you know, this is a little bit, maybe not dead end, but this is something which we already have, and it will be with us. So even if I sympathize with that opinion that it's beyond repair, what we can do, it will be for 20, 30 years. Still, even if we agree that it's beyond repair, there are sunset clauses. There are still investors counting already the money from the awards to be. So, you know, even if I agree with Gatti, with Ibironke, that the system is beyond repair, I don't follow their argument that taking part in the reform of the system, you are betraying somehow the rights of the third parties. So I don't know if it does. Yeah. There was no proper question for your answer, by the way.
It could well be that the sunset clause is just a bogeyman, in the sense that you can get rid of them bilaterally. Yeah. You know, there is that possibility. But looking at alternatives, you know, I mean, there are alternatives. There could be extraterritorial means of assessing liability. Yes. There are human rights courts which have dealt with the problem. So if you want other methods, I mean, there are other methods. So why go for these limited methods that you're suggesting?
The answer was at the last slide, which was just shown, and I didn't have time to comment that precisely I don't think that ESDS is the proper place also to discuss human rights. We have the human rights bodies. I think that, you know, strengthening the domestic system, putting more emphasis of the local law and how the investor, you know, protects or interact with that. But it means that you have the state who wants to go and battle for their own people. You know, the problem usually is that the state goes hand to hand with investor, and, you know, disregard the local communities and overlook the obligations which are already within their system. Thank so, you know, the emphasis, you're absolutely right. We should not be just focused on ESDS. The domestic law, the Brazilian attitude to make the domestic courts as a main forum to resolve the problem is the solution, in my opinion. However, we are where we are. We are with the situation as we are. So for that reason, intellectually, we work and we search for solutions very broadly.
Okay. So Niroshika and Shamila, I know to direct my questions to you. You talk largely about balanced treaties. I mean, you particularly, Niroshika, you said that there could be appropriate clauses like protecting the environment. And you, of course, stressed a social license, which has a similar idea. You know, so you have a balanced treaty, which would mean that you are really taking the old treaty that existed prior to, say, around 2004, and coupling exceptions to it. So the primary focus is on investment protection, right, which has always been the focus of investment treaties. Now you're creating exceptions. So the question that I want to ask you is, why is the protection of investments or the health and morals and welfare of a people, why are they so secondary to the protection of investment?
Thank you for that valid
that
question.
It should be an exception.
Yes.
And not the primary focus.
Yes. Thank you for that very valid question, Professor. Before that, just to, you know, to add one case relating to Professor Maciej, that answer. There is one interesting case that I could have find. It was Sauhoya-Maksa Indigenous Community versus Paraguay. This case was decided by the Inter-American Court of Human Rights. There, in this case, the indigenous community was claiming that Paraguay has violated their right to property by failing to recognize their title of their ancestral land. But interestingly, the court clarified this case, stating that investment law obligations of the state does not exempt the state from protecting and respecting the property rights of this indigenous community.
Sure.
So I find it as very interesting approach followed by the Inter-American Court of Human Rights.
There's a similar case decided by the African human rights courts as well.
Okay. Yeah, I find it as very interesting because normally, most of the time, these regional instruments are reluctant of going against the investment treaty regime. So, answering to the question that you have posed to me, Professor, yes, in this global economic era, all the states are in the pursuit of economic interest. So it is obvious that especially the global south states are in need of attracting more and more foreign investments, but still no research has pointed that there is a positive correlation between the foreign investments and entering into the bilateral investment agreements. But if I speak from my country's perspective, if we see the Ceylon Chamber of Commerce websites and also the BOI websites, they have recognized BIT as a strategic tool to attract the investors. But still, it is not that it is a tool that can attract the foreign investors. It is a legal binding it creates legal obligations actually. So this understanding is something still. Maybe it has been identified very clearly, but still the solution should be find out how we can mitigate the emphasis that have already been given to the foreign investors, and there should be a proper balance. The government officials might have very well identified because of the geopolitical concerns that the countries are facing. It has become very difficult for them to bring it to the negotiation table to provide proper space for the host state to legitimize their regulatory space.
Okay. So asking Shamila the same question, do you think that investment tribunals are equipped to make this balance and give effect to what you call a social license to protect?
Yes, when it's come to social license to operate or approve the project, it is, I believe that it is based on, it should included in the local law, right? So when it's come to indigenous people, as she pointed out that some treaties are outdated, but again it is based on the context, right? If you take Sri Lanka, we have 0.05 indigenous people, but in some other countries, they have large kind of compared to a significant number of percentage.
Oops, that's to remind me that time is running up. Pushka, all right? Yeah.
Order to, yes, yes,
yeah.
Proceed. Yeah, that is what, it is depend on the context, whether we go for reformation of bilateral investment treaties or whether the state, I think that these type of clauses should include in the investment contract where the host state can bring case against the investor under the contractual breach.
Yeah.
So that will be the maybe preferable way to include a lot of issues that as per the context of the country, the culture and the other environmental or even including these indigenous peoples.
Okay. And Caroline, if Caroline is still with us, can you sort of address the question whether ISDS tribunals are capable of addressing issues involving human rights?
Well, the older I get, the more skeptical I become of the whole enterprise, really. But if I may, I would like to just pick up on what was said earlier, and I think that this project of inserting ever more complex exceptions and clarifications and affirmations and preambles and carve-outs, whatever you want to call them, it's just not working. And, you know, the eco-oro case is, you know, obviously the most infamous example of that. And I think, and there's also the issue of framing things like addressing human rights and so on as exceptions, that these things should be exceptional rather than the ordinary business of a state looking after its people. It kind of turns the whole thing on its head, in my opinion. I don't know if I exactly answered your question, but yeah, thank you.
Okay. So do you have any questions to address? Yes. Yeah, I think we'll go with you. Yes, yes, please. No, yes. Can a microphone be?
So my question for the panel is, if one imagined a world in which ISDS was thrown out the window, what would replace it?
There was such a world.
There was. Would we be in a worse or better world, given the way capital would respond? Because capital, I would imagine, a foreign investor who wants to invest in Sri Lanka would say, I'm not going to just leave this to Sri Lankan law and Sri Lankan courts. They'll say, I want to bring this to, say, the International Chamber of Commerce in Paris, to private commercial arbitration, where there would be no transparency whatsoever. There would be no third-party rights. It'd be even a more sort of commercialized sort of set of arbitrators, as opposed to arbitrators who, such as you, Sona, and others. And so my question is, if we're going to throw it out the window as opposed to trying to reform it, what's going to replace it? Because capital has other means. Capital is not just going to say, you know, we'll use domestic courts. They're going to go towards potentially an even less transparent, sort of more biased system than ISDS. So.
Yes, Leila. Yeah, this is to the panel, not to me.
That's to you. That's to you.
Well, my answer to that is a simple one, that we always had a system on investment protection. It was only in 1991 that ISDS did take off. So there was a system prior to 1991, and people did make investments. And, you know, we did a study once in Singapore asking business people whether they knew about investment treaties. The large number of people did not know about it. They went into countries without knowing about it because of resource factors, availability of employment, and other reasons. Investment treaties did not play a role in their assessment of matters. So I think this is a fiction to say that they wouldn't go in if there are no investment treaties. We don't know about it. You know, I mean, it's.
I think they would go in. But I think the question is they use, you know, private commercial arbitration.
Sure, of course, yes. They could. Yes, which is a method, and of course it would be less transparent. Some investment ISDS cases are also non-transparent. So my answer would be that to a large extent, I think investment would proceed without being affected, even if we don't have an ISDS treaty. I mean, you yourself talked about asymmetries, and this is a classic instance of an asymmetry at work. And then if you talk in terms of power and justice, as you did, let me convince you that this is a system where there is a lot of inequity, and that therefore it should be done away with. Yes, I think, yes.
Thank you. I have a question which relates to indigenous peoples. I think that's very well articulated. However, my concern is in the light of, 2007 or 8, the UN General Assembly resolution on indigenous peoples and its for the host state to define under their charter or under their constitution or whatsoever what constitutes indigenous people, and that may even trip because some say, what? Do you have it or you don't have it? Check with the US, Canada, their definitions. So I think it's just something that is really quite tricky. So when you say they provide for it, okay, that's good, whatever that is, bearing in mind that UNGA, General Assembly Resolution, Declaration. The next thing is, what respect are you giving? Are you just giving consultation, or is it more than that? Are you giving the fact that their consent? That is what I would like to check in terms of the teeth that goes with it. Thank you.
Somebody answers? Yeah.
No, that's good.
Okay, right. This is regarding UNGP, the declaration on that is, I think, the non-binding instrument, right?
It is.
And yes, and that's what I said earlier. It is depend on the population they have to bring, and that is not only for the consultation, but also bring a legal mechanism to protect indigenous people's right at the domestic level. So, and if you see this ILO Convention 169, that is, I think, the majority of countries, they have, based on that convention, they have the domestic law with regard to protect. For instance, Canada, it has the Indigenous Rights Act. So, I'm also in the process of learning this particular topic. That's what I was discussing earlier, since it's the indigenous issues that come into the ISDS is very recently. And looking for this mechanism, for instance, these soft laws, the non-binding as well as soft laws, particularly the UNGP guidelines on the human rights. Not only we are looking into the indigenous people, we have to look into the local community, right? That's indigenous also part of the local community. However, they have kind of a distinct culture and the way of living because they are more attached to the land, and therefore these two instruments that bring more the responsibility to countries to have their own mechanism to protect them. I don't know whether I answered his question. Thank you. And I'm not saying that, but when it's come to the other general instruments, right, where they talk about the human rights and business, that generally it is all about the local community to protection of human rights, environment, and social. But it is not, I'm saying that too, the indigenous community also should come under the broader definition of community, but still, those will apply to them as well, because they are not different groups when it's come to the protection. But as these two instruments say that special care should be given to them. So their lifestyles are different.
Yes, one last question. Two last questions.
Okay.
Judge, yes.
I will try to be very, very short, but I have a question regarding the fact that you mentioned that it's maybe better to strengthen the domestic systems maybe, so that we can protect the indigenous peoples better. But for example, in the case of Ecuador, for example, first, well, there was the decision of Constitutional Court.
You're answering that,
yeah. There was the decision of Constitutional Court in which, it was against Texaco, I think, and Chevron, right? And then we had like the second decision of Chevron versus Ecuador, which was completely to reverse. And what is more, they had to even pay more than, well, the Chevron was supposed to at the beginning, right? So I have a question. What is the solution to that? Because obviously we can regulate it in the constitution, but then the arbitration still cannot care about that at all.
Yes. For instance, the indigenous people rights that include in the constitution and as well as local law. But when it's come to the ISDS, so that is what we say that the bilateral investment treaty should be reformed to include that component that's based on the percentage maybe, and as well as in the investment contract particularly. So investment contract can define as per the parties' wishes. So, and if the foreign investor violate that, the host state has a forum or bring the claim against the investor for human rights violations. So, that is what to bring this within this ISDS, somewhere that has to fit into the investment treaty or else investment contract.
Yeah, Judge,
Just
okay.
one comment regarding that. You know, the problem is that if we discuss the problems on the academic level and theoretically everything looks fine, but then when we got into deep or you are working the real case. So for example, the Ecuadorian Constitutional Court is passé because we don't like it. Colombian is good. On what basis? No? Then FPIC, for example, I remember one big project in Colombia when they were constructing the water dam, which was affecting the massive amount of people. And simply, I was in that, you know, I knew that case quite well. So the investor was like good guy in the sense that he wanted to contribute, he wanted to consult, he wanted to do even more than required. But then was so much disagreement among indigenous communities. They were, you know, if you have the big project which affects like 100 kilometers, you have the indigenous community which fights for ages between each other. So there, if that community will say yes, that chief will say no. So basically, to what extent FPIC should have the yes, no, or vote or the veto rights. So, you know, everything academically looks fine, and we can discuss for ages some standards. But then when you got into deep, you know, the facts matters in the case, and you can have the good investor, surprisingly, and you can have stubborn local communities which is just saying no, no, no. And you can have usually the investors which are just looking for profits and the local community which is affected. You can have good constitutional courts and bad constitutional courts. So, you know, this is very difficult to give you the answer which one size fits all. You know, that usually you have to look at the case, and usually the solutions in the details, in the facts of the case.
Yeah. The judge, yeah. Last question.
It's not working. Okay. The dilemma is, are you going to throw the baby or the bathwater, or do you want to throw both of it? The question is, you make up your mind. Do you want to preserve the baby, then throw the bathwater. Now, my suggestion is this. Why can't you have a carve out in the BIT saying that if you don't follow with regard to community rights, local community rights or third party rights, or the CSR rights, or the human rights, then you get no protection under the BIT. You will be governed only by the local laws.
Yeah.
The courts know what to do with them. Then, you see, why do you want a BIT? A BIT is a protection against sovereign exercise by the state of taking away your property. Now, if that property, that exception is denied to you, you will jolly well deal with the local courts, and they know how to straighten you. There is no difficulty on that. That should be an ideal solution. You keep the baby, change the bathwater, and carry on with life.
That's the conclusion, I think, of the
Yes.
question.
Very definite one. Thank you so much, Judge. Thank you, panel.
These tokens are represent our heartfelt thank for your time, effort, and dedication in making this discussion such a success. So let me kindly invite our panel chair, Professor M. Sornarajah, to distribute the token of appreciation. I would like to invite Dr. Maciej Zenkiewicz. Dr. Shamila Dawood. Ms. Niroshika Liyana Muhandirum. And also for Dr. Caroline Henckels. She's joining on that. Professor.
Thank you so much.